Five interim bail.
Please wait. Judgment.
The key pieces of evidence, including the consistent testimonies of the witnesses, the recovery of the weapon at the appellant's instance, and the medical evidence aligning with the injuries sustained by the victims, collectively point to the appellant's culpability. Moreover, the plea of insanity was carefully examined and found insufficient to undermine the appellant's criminal liability. From the discussions as above, we are of the opinion that the findings recorded by the learned trial court is found to be legal and justified, and therefore we do not hesitate to declare the conviction of the appellant as held confirmed. Since the sentence awarded is absolutely in accordance with law, there is nothing to interfere there.
I agree. Yes.
That appellant convicted for life measure. His brother died a day before yesterday.
What is the period of detention?
10 years already
Give
completed.
it, give it.
Interim bail.
Just
7 years in
give it.
Appellant Mothar was died on 3/7/2020.
What is the period of custody and counsel?
Period of custody is more than 5 years.
No, it cannot be listed here.
See the assignment.
The assignment you should see only in cases where 7 years he has remained in custody, that matter can be listed. So you can move.
7.
Are you sure? All right.
More than 9 years since it.
Yeah.
Item number 2.
May I please, when a 70 years old man in custody for near about 9 years for the implication of 302 and 34.
See, what is the date of custody?
8/9/2015.
What you said, 70 years.
Yes, my lord.
Okay. 302.
Yes. 302/34.
One deceased.
One deceased.
What is the name of the deceased?
Panchi Venudhara Sethi. Venudhara Sethi.
Venudhar Sethi. Eyewitnesses are there.
Yes, sir.
Who are the eyewitnesses?
PW4, who is the daughter-in-law.
Daughter-in-law of the deceased.
Other eyewitnesses are hostile. Basing on
PW4 has found hostile.
No.
So, and with the doctor?
PW17.
PM doctor.
Yes.
PW17.
Yes.
So, what is the prosecution case?
Prosecution case is that the informant and his father-in-law.
Father-in-law means the deceased.
Yeah. His basket some paddy on the road. One Bolero vehicle crossed there, and paddy are disturbed. For which there was a tussle between them, and 4 persons came with cobra and assaulted her and then his father-in-law. And the deceased died on the medical.
What happened to the other 3?
Other 3, 2 are not charge sheeted.
Okay.
And 1 is absconded, and
you only faced trial.
Yes, faced.
So, what is the specific allegation against you?
Specific allegation is that 4 persons assaulted by the crowbar.
Let us see PW4.
Yes.
Trial court report of PCR. PW4. Mrs. Sahoo, have you got the deposition copies with
I know.
you? So come to PW4. Yes. Please place the.
Yes. I know the accused Adikanta Sethi standing in the dock. So also the informant. Sorry.
So also the deceased.
PW for I read.
PW4
Yes,
is Panchali Sethi.
Panchali.
Ah,
I read.
he is the informant.
Yes, my lord.
Ah.
I know the accused Adikanta Sethi standing in the dock. So also deceased Venu Sethi. I am the informant in this case. One day in the morning, around 2 years back, I had sprayed paddy in front of my cottage to dry it. But Tukku Sethi, the other absconder, sped away one Bolero jeep over the paddy by driving the Bolero. As a result, the paddy was damaged. On this incident, I and my father-in-law Venu Sethi asked the accused Adikanda Sethi, Tukku Sethi, Kalandi Sethi, Babaji Sethi. Kalandi Sethi, Babaji is not just. And thereafter returned to the spot. When I was collecting the damaged paddy, the accused Adikanda Sethi and above other 3 persons, being armed with iron rods, reached at the spot, and the above 4 persons assaulted me and accused Kalandi Sethi caught hold my neck by his half-amputated left hand. As a result, I fell down on the ground. Then my father-in-law Venu then protested the accused person, but the accused and others assaulted him by means of iron rod. My father-in-law had raised his hand to ward off the assault, but the accused assaulted him. As a result of my father-in-law sustained severe injuries on his head, elbow, eyebrow, and chest, and my father fell down on the ground. When I raised commotion, the accused and others left the spot, and then I shifted my father-in-law Venu to government hospital Rajkanika, but the doctor advised me to shift the injured to Kotak, and thereafter I lodged a FIR before the IIC Rajkanika PS and shifted my father-in-law to SCB Medical, Kotak. This is my said FIR marked as exhibit, and exhibit 1 is my signature appearing thereon. On the day of occurrence, my father-in-law died in the night at
So
about
that means
11.
as it appears, this petitioner, his name is Adikanda.
Yes.
He, along with 3 other persons, out of which you said that 2 have not been charged. They are assaulted by means of iron rod.
Iron.
Now let us go to the doctor. Let us see what are the injuries sustained by the
PW 17. On 10 abrasion of
Last one is an abrasion, right elbow.
yes.
Second one is superficial lacerated wound, left arm. Contusion of size one, so left. Acha, ye 3 number ta this.
Yes.
Acha. The undersurface of the scalp contused on left oxygen. Okay. Brain showed contusion of so and so. So intracerebral hemorrhage was present in both occipital and frontal lobes, so and so. Okay. Yes, paragraph 7 here stated death was due to craniocerebral injury and complication.
Cross examination.
Is there any material that who dealt that fatal blow on the head?
No, all are attacked.
Into PW photo the
Glance on the statement of PW 6
cross examination doctor by fall that injuries can be.
it's all right. PW?
Other eyewitness also is there, my lord. PW 2, 3, 6 also eyewitness in this case.
He said that others have not supported the prosecution.
Supported the prosecution case, my lord. Have a glance on the statement of PW 6.
Tell us who are the other eyewitnesses there?
Other, my lord, PW 2,
Yes.
3,
3
and 6, my lord.
6.
My lord.
You are
6 wife of the deceased.
you want to place PW 6.
My lord.
What he has stated against this petition?
On para 2, my lord, my husband died around 3 years back. One day in the month of Jesta at about 10 a.m. in the morning, Tukku Sethi ran his Bolero jeep over the paddy spread by me in front of my cottage. When my husband protested, accused Adikanda assaulted on the head of my husband. The present petitioner is the Adikanda. Specific allegation against the
ତାପରେ କହୁଛି ଆଦିଗନ୍ଧ କାଳିଆ also
Held
assaulted my
use of an
husband.
iron rod and causing bleeding injury to the head of Adikanda and Kalia.
And what about the other two, Mrs. Sahu?
My lord,
ଆଉ
other
ଯୋଉ
two,
ଦିଟା ରହିଗଲା ତିନି ଆଉ ଛଅ ତିନି
two,
ହଁ ଟୁ ଟା କଣ କହିଲା?
କ୍ରସ ରେ ମନା କରିଛି I had not seen the occurrence.
କିଏ PW ଟୁ
Two.
କୋଉ ଲାଇନ ରେ?
Cross examination para 3.
ହଁ
I had also not seen the occurrence.
କୋଉଠି?
Para 3 cross examination.
The paddy is solution. I was not present at the time of. I had also not seen the occurrence. अच्छा.
but just after that he was stated that I had reached the spot while the quarrel was going on.
Okay. Then another who is left out is PW3.
PW3, my lord.
Adigam Seti so assaulted. He has stated in a
ପୁଣି cross ରେ କହିଛି
assaulted Punu Seti by means of iron rod, accused her assaulted on the head of the dog. So
I
except that PW6, as you said, yes,
Yes.
he is very specific that
My lord.
petitioner
ସିଏ ବି
assaulted.
ନଥିଲା.
Others have stated so single blow as it appears on the head, which has resulted in the cause of death,
My lord.
and he is in custody for it is
8 years.
almost 9 years, no, 8 years 10 months ago.
Age कितने year है?
7 years.
Are the Learned Counsel for the petitioner and counsel for the state? The Learned Counsel for the petitioner submits that the petitioner is aged about 70 years and he is in judicial custody since 8/9/2015. And as per the eyewitness account of PW4, the petitioner and 3 others assaulted the deceased by means of iron rod. But out of them, 2 have not been charge sheeted and 1 is still absconding. And the postmortem report would falsify the evidence of PW4 relating to the participation of 4 number of accused persons in the assault of the deceased. The Learned Counsel further submits that since it's an appeal of the year 2024, there is no chance of early hearing and taking into account the period of detention, the bail application may be favorably considered.
Is 60 years, not
At the time of trial.
at the time of trial when the judgment was passed, he was 60 years. And judgment has been passed in 2023.
And 60 years arrest time. 80.
তার চাকরি স্টেটমেন্টটা কিছু বলছি
This statement देखिए.
Statement said.
Charge दिन अभी 60 judgment. Yes.
Where is the accused statement? Where is it? 60 ହଁ ଆପଣ ନିଜେ ତ କହୁଛନ୍ତି 60 2023 ରେ ଆପଣ 10 ବର୍ଷ ପଢିକି କାଇଁ ଲେଖିଦେଲେ?
ଏଇଠି year of birth 60 ଲେଖିଥିଲେ
See,
ଯୋଉ
because
arrest
we are
ରେ,
considering
ଯୋଉ
the
arrest
also
କଲା ବେଳେ
while writing.
arrest କଲା ବେଳେ
दिन अभी 60.
ସେ ଲେଖିଛନ୍ତି
Charge
date
दिन
of
अभी 60.
Counsel,
Judgment दिन अभी 60.
your accused was examined. Accused statement was recorded on
Accused statement.
22nd August 2023.
Yes.
And on that day also, the Learned Session
Police
Judge
ଲେଖିଥିଲା।
posed that what is your age? He said that it is 60. You should have mentioned it 60. What is there?
ପୋଲିସ ଦେଇଥିଲା ସେତେବେଳେ 60
Police charge sheet to the 60 mention age. My
60
esteemed brother rightly pointed out. You see that? ଆପଣ
60
କୋଉଠୁ ପାଇଲେ?
year ବାରଟା 60 ପକେଇ ଦେଇଥିଲେ ମୁଁ ସେଇଟା
No, don't.
24 ହବା ଯାଏ 64
See, we are passing an order now.
Yes, ma'am.
Right now,
I
brother has passed an order
applied.
saying 70 years. So why should we go by that? We'll write the
60.
exact order.
Yes, ma'am.
Sir, 60 years person. 6 years also. The learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that apart from PW4, there are 3 other eyewitnesses to the occurrence, and they are PW2, PW3, and PW6. She also placed the evidence of PW17, the doctor who conducted post-mortem examination, and noticed 3 injuries, out of which one was on the parietal region, and opined that the cause of death was due to craniocerebral injury and its complication. Considering the submission made by the learned counsel for the respective parties, the surrounding circumstances under which the crime has been committed, the nature of evidence adduced, the period of detention of the petitioner in judicial custody, the age of the petitioner, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail. Yes.
Obliged.
Item number 3.
Badly placed.
Huh?
Badly placed man.
କିଏ?
S.S. Rao, senior advocate.
ମାନେ ଆପଣ ମାନେ କନସେଣ୍ଟ ଦେଲେ
ହଁ ସାର୍ ଚିଫ କୋର୍ଟରେ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ଆଫ୍ଟର ରିସେସ୍ ବି ଆଉ ଗୋଟେ ମ୍ୟାଟର ଫିକ୍ସ ହେଇଯାଇଛି ମଣ୍ଡେ ରହୁଛି ଓନ୍ଲି ଆଇ ପ୍ରେ ଫର ମଣ୍ଡେ ମ୍ୟାଟର ନାହିଁ
ମଣ୍ଡେରେ ଡିଫିକଲ୍ଟି କଣ ହଉଛି କି ନା ଯୋଉ
ଟ୍ୟୁଜଡେ ସାର୍ ରଖୁଛନ୍ତି
କେସ୍ ଆଡମିଶନ ଆଉ ଅର୍ଡର୍ସ ମ୍ୟାଟର ଗୁଡା ଗୁଡାଏ ପଳେଇ ଆସୁଛି
ଟ୍ୟୁଜଡେ ରଖିଦେବା ଓନ୍ଲି ସାର୍ ଓନ୍ଲି ବ୍ୟାଡଲି ପ୍ଲେସ୍ଡ
16th one.
ଆଜ୍ଞା
ମିଷ୍ଟର ଦାସ କଣ କହୁଛନ୍ତି?
ଏନି ଡେ ଓନ୍ଲି ସାର୍ ସେତିକି
Yes, Mr. Bhokta. The learned counsel for the petitioner submitted that a mention is made on behalf of Mr. S.S. Rao and senior advocate to take up this matter next week on consensus of all the parties. Put up this matter on 16th July 2024. Yes, Mr. Das. My lord. You said that you will give us 2 cases today. ଦୁଇଟା କେସ୍
ଆଜ୍ଞା ରେଡି
ଫୋନ କରୁଛୁ
39 ଫାଷ୍ଟ ପାସଓଭର ଗୋଟେ ଅଛି
ହଁ ଡାକି ଦିଅନ୍ତୁ
Passover item number 30.
Pariji, yesterday came that
channel one channel
behavior of Mr. Panigraj. Item number weekly number 30. He is unaware has some problem of vehicles coming Sunday.
He is coming.
Yes, possible.
39 Aramco.
Item number 39.
challenging the order dated 5 December 2009. Wish to argue on behalf of the state?
Yes.
Mr. Tripathi, you are-
Yes.
Please use the mic properly. Yeah.
The present appellant challenging the order dated 22 December 2009, minor
302.
302, live conviction,
Please come to the FIR. Place it.
minor.
And whenever any witness name comes, you tell that this is PW. Refer to the PW. Yes.
Informant name, minor Sukranti Naik, who is the wife of the deceased, minor.
What is PW?
Wife of the deceased, PW3, minor.
Please place it.
Minor.
This Bhanu Naik is the deceased in this case.
Bhanu Naik is the deceased. Date of FIR, 14/6/2018.
Okay.
And the date of death of deceased, 15th June 2018. 15/6/2018. Name of the deceased, Bhanu Naik, and name of the informant Sukranti Naik, who is the wife of the deceased.
Please place the FIR.
ମୋର ନାମ ସୁକାନ୍ତି ନାୟକ, ବୟସ 18 ବର୍ଷ, ସ୍ୱାମୀ ଭାନୁ ନାୟକ, ଘର କୁଳିଗସ, ଥାନା ଲୁହୁଣିପଡ଼ା। ଆଜି ତାରିଖ 14/2/2008 ତାରିଖ ଅପରାହ୍ନ 5 ଘଣ୍ଟା ସମୟରେ ଲୁହୁଣିପଡ଼ା ଥାନାରେ ହାଜର ହୋଇ ଏହି ମୌଖିକ ବୟାନ ଦଉଅଛି। ମୁଁ ଆଜକୁ 1 ବର୍ଷ ତଳେ ଭାନୁ ନାୟକକୁ ବିବାହ କରି କୁଲେଇ ପୋଷରେ ମିଳିଥିବା ସରକାରୀ ଘରେ ରହୁଅଛି। ଆମ ଘର ପାଖରେ ଆଉ ଏକ ସୁରଙ୍ଗ ତିଆରି ଘର ଖାଲି ପଡ଼ିଛି। ଉକ୍ତ ଘରକୁ ମୁଁ ଏବଂ ମୋର ସ୍ୱାମୀ ବ୍ୟବହାର
ସୁରଙ୍ଗ ନା ସରକାରୀ ଘର?
ସରକାରୀ ତିଆରି ଘର ଖାଲି ପଡ଼ିଛି। ଉକ୍ତ ଘରକୁ ମୁଁ ଏବଂ ମୋର ସ୍ୱାମୀ ବ୍ୟବହାର କରୁଛୁ। ସେଠାରେ ଆମର ପାଳିତ ଛେଳି ରଖୁ। ସେଇ ଘରେ 2-3 ସପ୍ତାହ ହବ ମୋର କକା ଶ୍ୱଶୁର ମକୁରୁ ନାୟକ, ପ୍ରେଜେଣ୍ଟ ଆପିଲାଣ୍ଟ, ଖପର ରଖୁଅଛି। ଗତକାଲି 13/6/2008 ତାରିଖରେ ଉକ୍ତ ଘରକୁ ତାଲା ପକାଇ ଦେଇଥିଲା। ମୋର ସ୍ୱାମୀ ମୋର କକା ଶ୍ୱଶୁର ମକୁର ନାୟକକୁ ଛେଳି ରଖିବା ପାଇଁ ଚାବି ମାଗିବାରୁ ସେ ଚାବି ଦେଲା ନାହିଁ। ଫଳରେ ଦୁହିଁଙ୍କ ମଧ୍ୟରେ ଝଗଡ଼ା ହେଲା। ସଙ୍ଗେ ସଙ୍ଗେ କାକା ମକୁରୁ ନାୟକ ଘରେ ତାର ଘରକୁ ଯାଇ ଟାଙ୍ଗି ଆଣି ମୋର ସ୍ୱାମୀର ମୁଣ୍ଡ ଓ ବେକ ଆଣି ଜୀବନରେ ମାରିଦେବ ବୋଲି କହି ହାଣିଦେଲା। ଯାହା ଫଳରେ ମୁଣ୍ଡରୁ ରକ୍ତସ୍ରାବ ହେଲା। ମୋର ସ୍ୱାମୀ ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ଟେମ୍ପୁରେ ପ୍ରଥମେ ଲହୁଣୀପଡ଼ା ଡାକ୍ତର ପାଖରେ ଲହୁଣୀପଡ଼ା ଡାକ୍ତର ଖାନା ଓ ପରେ ଡାକ୍ତର ପରାମର୍ଶ କ୍ରମେ ବଣାଇ ହସ୍ପିଟାଲକୁ ଆଣି ଚିକିତ୍ସା କରାଉଅଛୁ। ଆମ ସ୍ୱାମୀର ଚିକିତ୍ସା ବ୍ୟସ୍ତ ଥିବାରୁ ଆମ ପାଇଁ ଗତକାଲି ରିପୋର୍ଟ କରିପାରି ନଥିଲୁ। ଏଣି ମୌଖିକ ରିପୋର୍ଟ ଦଉଅଛୁ କି ଏହାର ତଦନ୍ତ କରି ଏହାର ଘଟଣା 13/8/2000 ତାରିଖ ଅପରାହ୍ନ 6 ଘଣ୍ଟା ସମୟରେ ହେଇଥିଲା। এই ଘଟଣା ଆମର ଗ୍ରାମର ଦଶମୀ
case was registered under 307.
307.
Then on the next day he died.
Right? No, on 15th June 2018.
Death on 15. Okay. Now this informant is the eyewitness to the occurrence.
Total
There are 4 to 5 eyewitnesses.
Kiye କହିଗଲ?
PW6, 7, 8,
just a minute. Eyewitnesses are PW
6, 7, 8, 9.
PW 6, 7, 8 and 9. And doctor, PM doctor, doctor, treatment doctor.
Doctor 15, PW 15, man.
Only one doctor has been examined.
No, man, 2 doctors.
PW 16.
PW 16 conducted postmortem and
PW just a minute.
16.
PW 16 is PM.
PW
treating doctor.
First aid, doing first aid. He referred to better matter.
PW kete?
PW 15.
PW 15. So this lady which you placed, Mr. Tripathi.
PW1 is also doctor, treating doctor.
Okay, so 1 and 15 are treated. So you said that 6, 7, 8, 9 are the eyewitnesses.
Eyewitness, my lord.
So what about PW3?
Mm,
PW3 the informant. She
info,
stated in the
my-
FIR as if she had seen the occurrence.
my lord, he was in the house, my lord. I am reading his deposition.
अरे eyewitness नुहे ताले FIR
Yes,
ଦେଇଛି ଯେମିତି ମୁଁ ଦେଖିଲି ବୋଲି ପରା
yes, she was a eyewitness, my lord.
କହିଲେ ନା କହିଲେ 6, 7, 8, 9 ନା କଣ କହିଲେ ସେଇଥିପାଇଁ ଆମେ ପଚାରୁଛୁ ତିନିଟା eyewitness କି ନାହିଁ
Three also eyewitness.
so
Three,
you
six,
start the evidence of PW3 then.
my lord. My lord, PW3, page number 32. I know the accused standing in the dock. Deceased is my husband. I was staying after marriage in my in-laws' house, and my deceased husband was tying goats in a shed lying adjacent to our house. The incident took place more than 1 year back in the evening at 7 p.m. The accused is my elder father-in-law. The goats of the accused and our were being tied in the shed. On the date of occurrence, the wife of the accused locked the shed. I requested the wife of the accused to hand over the key to unlock the shed on that day. When my husband was going on that day on that day going to the shed to tie the goats, the accused dealt blow by means of tanga on his neck. Second blow was given on his head, causing severe bleeding on his person. When I reached the spot, the accused fled away from the spot, seeing me. Then I brought my husband to my house. Then immediately I removed him to hospital. He died at Lohnipada Hospital. Lohnipada Hospital referred my husband to Bonai Hospital after 4 days. My husband died. I reported the matter at the PS Exhibit 4 is the FIR. Exhibit 4 by 1 is my signature.
So weapon of offense is tangia, one blow on the neck, the other blow on the head, right?
Yes, madam.
Okay, that is the consistent case of all the eyewitnesses.
Yes.
My lord, another thing is, my lord, the date of incident, my lord, date of incident 14/6/2018, my lord. Date of death is 15th June 2000, 15 June 2008. But the wife of the deceased in para 2, she stated that Lohnipara Hospital referred my husband to Bonai Hospital. After 4 days, my husband died.
After 2 days, not 4 days.
ଏଟା ବୋଧେ କଣ ଭୁଲଭାଲ
After
ଇଏ
2 days.
ବୋର୍ଡଟା କାଟି ଦେଇଛନ୍ତି
Two,
ବୋର୍ଡଟା କାଟିକି 2
after 2 days, he died.
ହଁ ହେଲାନି କି 13 ତାରିଖ ଧରି ଘଟଣା ହେଲା 14 ତାରିଖରେ FIR ହେଲା 15 ମଲା ତ କଣ ଭୁଲ କହିଲା କଣ
No, sir, 4
After
will
2 days my husband died ପୁରା କହୁଛି
sorry, sir, 4 will you have believed.
ଆରେ ନାଇଁ 4 ଟା ଆଗରୁ ଟାଇପ କରିଥିଲା ତାକୁ ପୁରା କାଟିକି 2
ଆଜ୍ଞା,
କରିଛି
ଠିକ
ଜଣା
ଠିକ
ପଡୁଛି ଯେତେବେଳେ ଟାଇପ ମେସିନ ଥିଲା ତାକୁ ଭୁଲ କରିକି ଥିଲା ତ କରେକ୍ସନ ହାତରେ କରାହେଇଛି
No.
okay so anything has been brought out in the
Cross
examination.
My lord, the quarter located in the colony bounded with a wall. On the date of incident, my in-laws had been to their in-laws house. On that day, I was only present in the said house. One Gomha and Boise and the house of the accused are adjacent to our house. The house wherein the God were kept belongs to accused. There was a good relationship in between our family and the family of the accused, and I was giving proper treatment to them. And I do not comprehend as to how the accused killed my husband. At the time of alleged incident, I was in my house. I did not hear any quarreling going on between the accused and my husband. On hearing the halla of my husband, I came out from the house. I heard the sound of blows given to my husband by the accused. Then I immediately came out and saw further assault to my husband. It is not a fact that the accused also hearing the sound of the blows came to the spot, but he came earlier and assaulted my husband. Then I cried aloud as maridali ମାରିଦେଲେ on hearing my cry. The neighboring people came to the spot. The brother of my husband was also present in the house. He also came to the spot with the wife of the accused. My husband was in conscious stage till he he is being treated in the hospital. The police did not come to the hospital during that time. I cannot say in how many papers my signature uh, was obtained by the police. I cannot say the content of those paper where my signature was obtained by the police. The police obtained my signature in our village. The police once come to our village. I have been examined by the police. I did not go to the police station. The FIR was lodged at the hospital before police. The content of the FIR was not read over and explained to me. It is not a fact that I have not seen the incident nor the accused has committed murder of my husband.
So what is your submission on this?
My humble submission is that manner. He was not seen the occurrence manner.
Why?
As because manner she clearly stated that during the incident I was in the house.
No, at the time of alleged incident, he was in the house. Alleged incident does not mean that throughout he was in the house. Maybe that ସେ ଯୋଉ quarreling period ରେ ହୁଏତ ଥାଇପାରେ ତାପରେ ପାଟି ଶୁଣିଲା ପାଟି ଶୁଣି ବାହାରକୁ ଆସିଲା ପାଟି ବାହାରକୁ ଆସିକି ଦେଖିଲା ବି ସେ କହୁଛି I heard the sound of blows ଆଉ then I immediately came out and saw further assault. ତାମାନେ ହୁଏତ second blow ଟା ସେ ଦେଖିଥିବ
second blow ଟା ସେ ଦେଖିଛି ବୋଲି କହିଲା କିନ୍ତୁ
ଯଦି ଦିଟା blow ଆପଣ କହୁଛନ୍ତି total ହେଇଛି, is it correct or not? There are only two blows on the
two blows.
So two blows ହେଇଥାଇପାରେ. What is the probability feature?
Two blows ସେ ଗୋଟେ blow ମୁଁ ଦେଖିଛି ବୋଲି କହୁଛି. Another thing is man during my husband was in conscious stage till he is being treated in the hospital. But there is no dying declaration recorded by the police or the medical officer.
Dying declaration ହୁଏତ କହିବାର ସେ ତାର ନଥିବ ତାର ନେକରେ ମାଡ ହେଇଛି ତେଣୁ ସମସ୍ତେ କଣ dying declaration କରିକିନି ମରିବେ ବୋଲି ଏମିତି କିଛି ଅଛି କି?
Another point is minor. He was stated the brother of my husband and wife of his brother. They are not charge sheeted witness in this case.
No, it's all right. He said that as many as 4 eyewitnesses are there apart from PW3. All of them have stated that it is you who assaulted by means of that tangia. So you see, she is not likely to spare the real culprit. And she being the widow of the deceased, why she would falsely implicate? You have got good relationship also. So there is no any such enmity that she will implicate you. See, you have extracted in the cross-examination that there was good relationship.
But the question arises, minor the appellant and deceased, they have also a good relationship. There is no motive, there is no preparation.
Paragraph 3 re she କହୁଛି there was good relationship between my family, our family, and the family of the accused. ତମ ଆପଣଙ୍କ ଭିତରେ ଉଭୟ ପରିବାର ଭିତରେ ଭଲ ସମ୍ପର୍କ ଥିଲା ତେଣୁ ଘଟଣା ଦିନ ଯୋଉ ଛେଳି ରଖିବା ପାଇଁ ସିଏ ବନ୍ଦ କରିଦେଇଥିଲା ଆପଣ ଛେଳି ରଖିବା ପାଇଁ ତାକୁ ବୋଧେ ଖୋଲିବା ପାଇଁ ସେ ଘରକୁ କହିଛନ୍ତି ତାପରେ ଏଇ ଘଟଣାଟି ହେଇଛି
ସେଠି ଗଣ୍ଡଗୋଳ ହେଇଛି due to sudden provocation manner the appellant committed this crime.
Mr. Tripathi, yes, that is the consistent case of all the eyewitnesses.
Yes.
Let us go to the next one. This is PW6.
PW6 manner. May I place it? I know the PW6 is Dasami Naik. I know the accused Mokaru Naik. The incident took place in the month of Raja of the year 2008. In the evening on that night, I was cleaning rice. While the deceased was going to tie her goats, the accused came and by means of a tangia assaulted on his head, and then out of fear I went inside my house. When again I came to the spot, found the deceased sustained injury on his head and neck. The house of the accused is situated within 2 houses from my house, and all the houses standing on the road, and the road is leading by the side of the colony. There are so many houses in the colony. The government has established the colony. All the inhabitants of the colony were also in their respective house at the relevant time. I did not hear any halla prior to the incident. I got good relationship with the accused. I had no inimical relationship with him. While cleaning the rice in front of the house, I saw the incident. It is not the fact that I have not seen the occurrence, and that I am deposing at the instant of PW5.
So again, we are asking you that this evidence corroborates PW3.
Madam.
So same thing he has stated about one blow he has seen on the head.
Madam, 7, 8, all are during cross and
Seven
cheek.
also stated about on
Same,
the head
same madam.
and
Head and neck.
head and neck.
Head and neck. 8 also same
Eight.
madam. But in 8 madam,
And let us come to the doctor's evidence. The doctor who conducted post-mortem examination, and you said that it is PW16.
madam.
That is at page 52. Achha.
In the doctor, on 14th June 2008, on police requisition, I conducted autopsy of the Bhanu Naik, being identified by Constable 1058 and other.
So your submission that the death took place on 15th cannot be correct.
Correct, madam.
Because if the PM was conducted on 14th,
14th.
so that means on the very day,
Hmm.
on the next day of the occurrence took place on 13th. On the
Madam.
next day he died. The
No,
date on which the FIR has been lodged.
15th June 2008 he died.
Food ପାଇଲେ ଆପଣ ଦେଖିଲେ ଏଠି ପଢୁଛନ୍ତି ଅଟୋପସି ପରା 14 ତାରିଖରେ ହେଲା 15 ତାରିଖରେ କଣ ଡେଥ୍ ହେଲା
ଇନକ୍ୱେଷ୍ଟ ହେଇଛି 14th ରେ
ଇନକ୍ୱେଷ୍ଟ ଟା କେବେ ହେଇଛି ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ଟା ଟିକେ କେତେ ନମ୍ବର ଏକ୍ସିବିଟ୍ ଟା
ଏଟା ଭୁଲ ହେଇଛି
ଭୁଲ ହେଇଛି
307 ହେଇଛି
ନାଇଁ 307
PW1 treating doctor. He said, I declared him dead on 15/6/8.
ଆଚ୍ଛା ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ଟା କେତେ ଅଛି ପିଡବ୍ଲ୍ୟୁ ଏକ୍ସିବିଟ୍ PM ଟା ଦେଖୁଛି 21 IO PW Mr. Tripathi
Yeah. IO PW15 मिला.
PW15
Yes.
Madam.
ଇନକ୍ୱେଷ୍ଟ ହେଇଛି ତ 6/11 no ADJ that is exhibit
Yeah, he said, IO said the 15/6/2008, and I received telephonic message that the injured died, expired.
Okay, maybe it's a wrong statement that you given.
16
15 ରେ ହୁଏ ତ ହଁ ଏଇଟା ହଉଛି
date of autopsy is
ଇନକ୍ୱେଷ୍ଟ 5/2
that is 16
5/2 ଟା ଟିକେ ବାହାର କଲା
16
ଏକ୍ସିବିଟ୍ ଲିଷ୍ଟ ଅଫ କ୍ଲିକ୍ କର
16/6
କୋଉଟା ଇନକ୍ୱେଷ୍ଟ
Dying declaration is there also.
ହଁ we'll see 50L5 ହଁ ଇନକ୍ୱେଷ୍ଟ ଆଇଛି 16 ତାରିଖ ତ ଏଇଟା ଏ ଡକ୍ଟର ଭୁଲ କହିଛନ୍ତି ଇନକ୍ୱେଷ୍ଟ ହେଲା 16 ତାରିଖ 16 ସମୟ ଦେଇଛି ଦିନ 10ଟାରୁ 10:30ରୁ 11ଟା ତାମାନେ PM 16 ତାରିଖରେ ହେଇଛି ଏଟା ଭୁଲରେ କହିଛି okay so you just place that evidence of the doctor who conducted PM.
Malo.
16, PW 16.
That on 14/6/2008 on police requisition I conducted autopsy of Bhanu Naik being identified by Constable 1058 and others and found the following. Victim was well built, rogomoritis present all limb. Injury
Rigor
one,
mortis present in all limbs.
all limbs. Injury lacerated wound with antemortem stitches. 5 centimeter into 1 centimeter depth, 1.5 cm on right temporal region of scalp. Second injury, lacerated wound with antemortem stitches of sieve, size 6 cm into 2.5 cm depth on left nape of the neck. Abrasion 3 centimeter into 1 centimeter on left knees joint. 3 injuries there. Internal finding. All the layers of reaching of two skull bone and outer table of the right femoral bone broken with normed nor, norm
With formation of subdural
normation of
hematoma. Hematoma size ଦେଇଛି 8 cm into 3 cm.
CSUM just
below
below
the
the
fracture of the
fracture of
right
right
temporal
temporal
bone.
bone. Brain is intact but congested body of the third cervical vertebra is fractured with formation of hematoma size 3 into 2 centimeter, which is compressingly spinal cord. There is a laceration at the nape of the neck, chest,
Up to the third
up to the third vertebra. All internal organs like lung, kidney, hearts are intact, but congested stomach is intact and contained around 200 ml of yellowish fluish liquid materials. Cause of death, cerebral hemorrhage. Time since the death of 18 to 24 hours. This is my report. Exhibit 2. Exhibit 2/1 is my signature. On 21 by 1 is my signature. On 5/9/2008, on police requisition, I conducted the examination of the weapon, that is X. My lord, on 5/9/2008, on police requisition, I conducted the examination of the weapon, that is X, produced before me by crime Havildar D.N. Sahu and opine 1. The injury could have been possible by the weapon of offense produced before me for my examination, and the injuries being found on the vital part of the body could have caused the death of the deceased. This is my report, Exhibit 14/2 and Exhibit 14/3, 19/2 and 19/3 is my signature. In cross examination, the disease was indoor prior to PM examination. He was being treated by the surgery specialist. It is not a fact that I have not been authorized to conduct autopsy over the dead body of the deceased. Cerebral hemorrhage can be caused due to several causes. There were there were no foreign materials found on the injuries detected by me. During postmortem, injury number 2 can be possible by fall on glass pointed in surface. I don't have any knowledge regarding method of treatment administered at the initial stage of the patient. It is not a fact that I have not properly conduct autopsy over the dead body of the deceased, nor the injuries could be possible by the weapon of offense referred to for my examination and opinion. The X produced before him on 5/9/2008 and date of incident 13/6/2008 and
that is, why didn't you put a question that there are two lacerated wounds then, and it is a sharp cutting weapon as appears from that 15 19 exhibit 19 এটা जेटा को साइड रे ही परियो बोली पचारलेन गोटे शार्प साइड अछि गोटे ब्लॉन्ट साइड अछि
That is, he was asking, it is not,
अपन तार लेंथ टा होची 26 इंच वुडन पार्ट टा होची 100 लेंथ ऑफ द आयरन टा होची 5 to 4 5.4 ब्रेड्थ टा होची एति की diameter 100 very
injury number 2 can be possible by fall on glass pointed surface.
no, that is
Sir,
not the thing. The thing is that he was supposed it would have come that no, he has not assaulted, used the sharp side, but the blunt side has been used. ये जो पछपट्टा ये then because of the lacerated wounds caused, then nothing has been brought out in that right.
Autopsy of the I have not been authorized to conduct autopsy over the
Point धर ये कहूँ अपन point कौन धरुଛନ୍ତି कौन point a person having a sharp cutting weapon is not using the sharp side but the blunt side is used, and if sharp side would have been used the neck portion would have there would have been a cut injury incised wound on the neck, but it appears that it's a lacerated wound. So that means that sharp side has not been used. It's a the other side has been used, and there are decision to that effect that if a person is having a sharp cutting weapon uses the other side, then what would be its impact? Whether it would be a 302 or 304 part 1, ସେ type light ରେ ସେଥିପାଇଁ ପଚାରୁଥିଲି आप କିଛି ବାହାର କରିନାହାନ୍ତି Have you brought those decisions which you are referring to? That if a person is having a sharp cutting weapon, do not use the sharp side but the blunt side, then ମୁଣ୍ଡଟା କଣ
I would that
No, that could not have been your case because you have put a suggestion,
manner actually more
presuming that it's a cutting.
manner
That is how you are putting a suggestion that ଯଦି glass ଉପରେ ପଡିବ it's a laceration.
manner.
So your case is different.
lacerated wound ଟା କେମିତି ହବ କୋଉ ସାଇଡ୍ ର ହବ ଏ କ୍ୱେଶ୍ଚିନ୍ ସବୁ ପଚାରିଥିଲେ ତାକୁ lacerated wound ହବ sharp cutting weapon ହେଲେ କଣ ହବ ଏଗୁଡା ପ୍ରଥମରୁ ଆଣିକି ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ ଆପଣ ପାଖକୁ ଏଇ weapon ରହିଥିଲା ଏଇ portion ଟା କରିଥିଲେ କୋଉ type ର injury ହେଇଥାନ୍ତା ନିଶ୍ଚୟ କହିଥାନ୍ତା cut କି ଅମୁକ ହେଇଥାନ୍ତା ଯଦି neck ବି ହେଇଥାନ୍ତା lacerated wound ରହିଛି ମାନେ ଏଇ weapon କୋଉ portion ଟା ଭାବୁଛନ୍ତି ଆପଣ ହେଇଛି ଏଇଟା ହିଁ ହଉଛି କେସ୍ ର ବଢିବାକୁ ତାକୁ ଗୋଟେ କଳା ଅଛି गुड़ा ये जो क्वेश्चन गुड़ा सब पचरा जाए ग्लास ऊपर पड़ले से हमको ऊपर पड़ले जा unless you prove something brought out something in the defense that in fact he fell down on such ये गुड़ा का देगी नहीं किसी लाभ होना ये टाइप रो सजेशन देगी नहीं
but my lord, total investigation clearly says that
ଆପଣ
the
କ୍ଲାସ୍ ଉପରେ ପଡିକିନା ଆପଣ ଆଣିଛନ୍ତି କିଛି ଏଭିଡେନ୍ସ ସେ ଜାଗାରେ ଯୋଉଠି ହେଇଥିଲା ଭଙ୍ଗା କ୍ଲାସ୍ ଥିଲା ବୋଲି
ନା actually without motive ଉପରେ citation କେତେଟା ଆଣିଛି
ଆପଣ କୋଉ ଟାଇପ ର ୱେପନ ଧରିଛନ୍ତି କୋଉ କୋଉ ଜାଗାକୁ ସିଲେକ୍ଟ କରୁଛନ୍ତି ମାରିଲା ବେଳେ ଇଣ୍ଟେନସନ ଟା କେମିତି ଗ୍ୟାଦର କରିବ ଆପଣ ଶରୀରର ବିଭିନ୍ନ ଅଙ୍ଗ ପ୍ରତ୍ୟଙ୍ଗ ରହିଲା ଆପଣ ଦିଟା ଜାଗାକୁ ଚଏସ୍ କଲେ ଗୋଟେ ହଉଛି ମୁଣ୍ଡ ଆଉ ଗୋଟେ ହଉଛି ବେକ
ଦେଖ
ରାଇଟ୍
ଆଜ୍ଞା
ଏବଂ ଇଞ୍ଜୁରିର ସାଇଜ ଟାକୁ ଦେଖନ୍ତୁ କୋଉ type ର length ଅଛି କେତେ depth ହେଇଛି ତାର impact କଣ ଆସିଲା, that is one of the criteria also. Intention ପାଇଁ କିଛି ଗୋଟେ straight jacket formula ନାହିଁ ଯେ ଏଇ type ର ବିଭିନ୍ନ surrounding circumstance ରୁ ଦେଖିବାକୁ ପଡିବ ଯେ attendant circumstances ଆପଣଙ୍କର conduct କଣ, କୋଉ type ର weapon use କରୁଛନ୍ତି, କୋଉ type ର force use କରୁଛନ୍ତି, କୋଉ part of the body select କରୁଛନ୍ତି, ଏଇଥିରୁ ଆସିବ ନା।
ଆଜ୍ଞା। କାଲି I will satisfy. କାଲି ଗୋଟେ
Spare some time for the case. Unless you spare some time for the case and go between the line in the evidence, whatever suggestion you are putting, kindly make use of.
You are aware that this is a jail criminal appeal, so maybe the State Defense Council might be conducting the case,
ନାଇଁ
but still then
Dying declaration.
dying declaration ଟା କେତେ ସେଟା
ସେଟା ହେଇନି।
ଡାଇଂ ଡିକ୍ଲାରେସନ ହେଇନି।
exhibit 15 ଟା ତାହେଲେ କଣ
ସେ ଲେଖିଛନ୍ତି କି
exhibit 15 ଲେଖା ହେଇଛି dying declaration,
dying declaration, but the IO said that he is not conscious. Also,
let us see that exhibit 15.
exhibit 50 SDM for recording of dying declaration of the injured by the magistrate made exhibit 15. But since the injured was not in conscious state, dying declaration could not be made. Yes.
नहीं exhibit list रे से exhibit 15 केमती लिखी थी dying declaration और
That is the requisition.
requisition टा लिख दी थी
Requisition by the IO to the SC.
तो से लिखी थी exhibit रे dying declaration हाँ से लिखा ही था पर लिखा ही जो I visited so and so, but it is found that Bhanu Naik is not in a condition to speak anything.
Yeah.
B.N. Das, SDMO, is also present. Hence, dying declaration could not be taken by me. This is for your information and necessary. So that is there. କଣ ପାଇଁ କଳିଟା ହେଲା ସେ କହୁଛନ୍ତି ସାକ୍ଷୀ ମାନେ
That the house belongs to the accused person. Accused. The deceased kept goat inside this house.
house ଟା accused ର
Yes, ma'am.
ଆଚ୍ଛା ହଁ ସେଇଟା କହୁଛି ଇଏ ତା ସ୍ତ୍ରୀ ମଧ୍ୟ
ହଁ।
ହୁଁ
ସେ ରଖୁଥିଲା ତାପରେ ଯେତେବେଳେ ସେ ତାଲା ପକେଇଦେଲା ଇଏ ଆଉ ଛେଳି ରଖିପାରିଲାନି ସେଇ କଳି ହେଇଛି ଆଉ।
ନା ନା ତା ହାଉସ ନାହିଁ, ସେଟା ହଉଛି ସରକାରୀ ଖୋଲା ଜାଗାଟା ଥିଲା, ସେଠି ସେମାନେ ମାନେ କାଉ ସେଟ୍ କରିଥିଲେ।
ସେଟ୍ ଗୋଟେ
Shed ଗୋଟେ କରିଥିଲେ, ମାନେ ଘର ମାନେ ନୁହେଁ ସେ
କମ୍ପାଉଣ୍ଡ ଭିତରେ that is fenced by wall
ହଁ
and
ସେଠି ଛେଳି ଗାଈ
ଛେଳି
ରଖୁଥିଲେ
ରଖିବା ପାଇଁ ଗୋଟେ shed
compound ଭିତରେ
କରିଛନ୍ତି
ଥିଲା ସେଠି ତାଲାଟା
ହୁଁ।
ପଡେ।
କିନ୍ତୁ ଆଇଓ ଡିଫରେଣ୍ଟ କଥା କହୁଛି। PW 15 that on 14/6/2008 I was IIC Lohunipada PS on that day at 5:30 p.m. Informant Sukanti reported orally, basing on which I drew up oral report of informant and prepared the FIR after read over and explained the contents thereof. This is my endorsement and signature. Exhibit 4/2 and Exhibit 4/3 is the normal FIR. Exhibit 4/4 is my
Normal affair, not normal.
Formal FIR. Sorry, signature. During the course of investigation, I examined the informant, the other witnesses, and visited the spot. Exhibit 12. In the spot, Exhibit 12/1 is my signature, and I see sample earth, the blood stained earth from the spot. including some other articles. That is napkin, by Exhibit 13. Exhibit 13.1 is my signature. I also seized towel stained with blood from the veranda at Kuldeep Kul Kulpos by Exhibit 14. Exhibit 14.1 is my signature. I moved the SDGM for recording of dying declaration of the injured by the magistrate by Exhibit 15. But since the injured was not in conscious stage, dying declaration could be made. Exhibit 13 is the seizure list. In respect of napkin towel, MO4 is the towel napkin. On 15/6/2088, I received telephonic message that the injured expired. Uh, my lord, that is not in the arrested on minor 17/2008. No man. नहीं. Jail criminal filed on 2010. Korea 2/2010. Korea 2/2010. My lord, in IO Chief Examination in Para 4, my lord, on 17/6/2008, I arrested the accused Nakul. While in police custody, he confessed and gave recovery of weapon of offense, that is Tangia, in presence of witness. Exhibit 8/2 is the statement record under Section 27 of the Evidence Act. Exhibit 8/3 is my signature. I have obtained the LTA over the body of the statement. Exhibit 6/3 is my signature. MO1 is the Tangia. But the doctor says they produced the Tangia on September month. After 3 months, they submitted before the doctor for examination. She goes on 5/9/2008 on police requisition. I conducted the IO goes on 17/6/2008. I arrested accused Nakul recover.
ନା ସେଇଟା ପଚରା ହେଇନି କି ସେ ବି
କହି ନାହିଁ
କ୍ରସ୍ ବି କରୁନାହାନ୍ତି ନା କିଛି
Yeah, my lord, before PW16, IO has examined.
So the discrepancy that you need to bring on record is with respect to the weapon of offense perceived was not the one placed before the doctor. So that could have been your key. That is not there.
डॉक्टर को क्यों पछा डॉक्टर तो पछा डॉक्टर आफ्टर आयो डॉक्टर आयो हाँ आयो before doctor आयो has been examined in this case.
So it is not important after is the weapon. It is important
That
whether the same weapon of offense which is said to have been seized on a particular date was the one produced. Otherwise, no. So that person would have been a higher power than the doctor. And what question would have been to the doctor? That it was kept under seal or not, whether he opened the seal, all these questions. I am not saying that this article was kept under seal.
No.
And there is no question.
PW1.
Not one. Now, one are declaring that
I was working in my present post at 7:30 p.m. on that day when Bhanu Naik came to emergency OPD, which was referred case of Lohunipada. Hospital, I admitted him. Lohipura doctor examined. Madam.
the patient was treated with one interception from Florida.
कि डॉक्टर जैन है I gave started IV fluid and injection was administered on him on 15 June 2018. Again, I being MO. After receiving call from staff nurse, I found him gasping stage. I provided all cardio measures. The patient could not survive and died. I declared him dead on 15/6/2008 at about 8 p.m. I informed the matter to SDMO Bonai. Exhibit 1 is the reference slip. Exhibit 2 is the bedhead ticket consisting of 2 sheets. Exhibit 2/1 is my signature. In cross-examination, I did not inform the police only because it is a referred case of Lohunipada. There is no facility for the treatment of cardio patient at Bonai. I have only tested the patient clinically preliminarily. It is not a fact that I have not properly treated to the patient. May I pray one thing, Shamala? My lord,
Yes, ma'am. Motive is no, Miller. Motive is there. That keeping the goat inside the house of the accused. Keeping, but particular day he has kept lock. Yes, ma'am. Yes. Refused and started quarreling. Yes. Floor. Cotton. Yes. Inside. Treatment, yes. Yes. Surgeon Specialist Dr. P.K. Das Asilini. No treatment. IV fluid and injection are administered. Yes, that's
16 years.
The serial number 8 of 2010. The appellant Mokuru Naik faced trial in the court of Learning ad hoc is Learning additional session judge, fast track court Rourkela, Kyam Banai in session trial case number 83/56 of 2009 for commission of offense under section 302 of the Indian Penal Code on the accusation that on 13th June 2008 at about 6 p.m. at village Puli Post under Lohuni Pada police station, he committed murder of one Bhanu Naik, hereafter the deceased bracket ভিতরে, by means of a tangia. The Lenin trial court found the appellant guilty under the offense charge and sentenced him to undergo imprisonment for life. The prosecution case, as per the first information report lodged by Sukanti Naik, bracket PW3, the widow of the deceased, on 14/6/2008 before the IIC of Longnipada police station. In short, is that she married the deceased about 1 year prior to the date of occurrence, and they were staying in a government after constructing a house in a government land in village Kulei Post. They had also constructed a shed adjacent to their house and which was lying vacant, and they were using the same for the purpose of uh, the keeping the cattle, goats. Like 2 to 3 weeks prior to the date of occurrence, the appellant, who was related to the deceased as uncle-in-law, or to the informant as uncle-in-law, also constructed uh, a house there and that was staying there. On 13/6/2008, the appellant logged uh, the premises which was used by the informant and the deceased for keeping the goats. The deceased asked for the keys of that safe to the appellant, but it didn't give the same, for which there was altercation between the appellant and the deceased. During course of such altercation, it is stated that the appellant brought a tangia and assaulted on the head as well as neck of the deceased, for which there was profuse bleeding, and the deceased was in an injured condition, was immediately shifted to Lohunipada uh, uh, hospital first, and then, as per the advice of the doctor, he was taken for treatment. Though the occurrence in question took place on 13/6/2008, but since the informant (PW3) was busy in the treatment of the deceased, uh, she could not lodge the FIR on the date of occurrence, but on the next day, that is on 14/6/2008, and accordingly, Lohunipada PS case number 144, dated 14/6/2008, was registered under section 307 of the Indian Penal Code. PW15, the IIC of Lohunipada Police Station, himself took up investigation of the case, examined the informant (PW3) and other witnesses, visited the spot and prepared the spot map exhibit 12. He also seized sample earth and bloodstain earth from the spot, including other articles, that is napkin as per seizure list exhibit 13. He also seized a towel stained with blood from the veranda at Kuli Post as per seizure list exhibit 14. He took steps for recording the dying declaration of the deceased who was then in injured condition in the hospital, but the but the dying declaration could not be recorded as the deceased was not in a conscious state. On 15/6/2008, PW15 received message regarding the death of the deceased, and accordingly, the case turned to one under Section 302 of the Indian Penal Code. PW15 conducted inquest over the dead body and sent it for autopsy to S.D.H. Bonai. And after the postmortem, the wearing apparels of the deceased were seized. The appellant was arrested on 17/6/2008, and while in police custody, he gave recovery of the weapon of offense, that is tangia, in presence of the witnesses, and which was seized pursuant to the statement recorded under Section 27 of the Evidence Act. He also issued requisition to the medical officer Lahunipada PSC for examination of the appellant and seized the biological sample of the appellant, which was produced through escorting constable, and then forwarded the appellant to court. He received the postmortem report. He also made a query to the medical officer regarding possibility of the injury sustained by the deceased with the weapon seized, and got the report. He also seized the bedded ticket of the deceased and made a prayer to the SDGM Ponai for sending the exhibits for chemical examination, and accordingly the exhibits were sent. On completion of investigation, he submitted charge sheet against the TCR trial court report. Final form. He submitted charge sheet on 2/10/2008 under Section 302 of the Indian Penal Code against the appellant. After submission of charge sheet, the case was committed to the Court of Session following the due procedure, where the appellant was charged as aforesaid. Since he pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 16 witnesses. The prosecution also exhibited 21 documents that they were. Also proved two material objects, so and so. The defense plea of the petitioner, appellant, was one of denial. The London trial court, after assessing the oral evidence of the witnesses, particularly the evidence of the eyewitnesses PW 3, 6, 7, 8, and 9. So also the postmortem report finding came to hold that the evidence adduced by the eyewitnesses that there is no concoction or fabrication in the evidence adduced by the eyewitnesses. And the medical evidence also corroborates the evidence of the eyewitnesses, and taking into account the evidence relating to the recovery of the weapon of offense, that is Tangia, at the instance of the appellant, basing on his statement recorded under section 27 of the Evidence Act, the London trial court held that the same is an additional circumstance against the accused, and in view of the doctor's report that the injury caused the disease was possible by the weapon which was recovered at the instance of the appellant, it can be said that the prosecution has successfully established that the petitioner is that the appellant is the author of the crime. The London trial court did not give much importance to the argument advanced by the London Defense Counsel regarding the delay in lodging the FIR, and held that there is no deliberate delay, and it has been explained by the informant. The London trial court held that the case presented by the prosecution against the appellant is well founded and intrinsically true, and there is existence of abundance evidence and semblance of truth that the appellant is the perpetrator of the crime, and accordingly held the appellant guilty under section 302 of the Indian Penal Code. The Mr. Rajiv Lochan Patnaik, learned counsel appearing for the appellant, argued that the evidence of the eyewitnesses should not be believed, and PW3 could not have seen the occurrence as she was inside the house when the occurrence took place, and even though the prosecution case is that a sharp cutting weapon like Tangia has been used to assault the deceased, but the injuries sustained are lacerated wound. Therefore, the ocular testimony goes against the medical evidence. The learned counsel further argued that the circumstances under which the occurrence has taken place, and since there was no previous enmity between the parties, rather there was good relationship between the family of the deceased and the family of the uh, family of the appellant, and in fact they are related to each other. It cannot be said that the appellant there was any motive behind the commission of the crime, and it appears that on account of sudden quarrel, the uh, appellant uh, assaulted the deceased, and there is also evidence that proper treatment has not been provided to the deceased, which would be evident from uh, evidence of PW1, and therefore the conviction under section 302 of the Indian Penal Code is not sustainable in the eye of law, and the uh, uh, since the uh, petitioner, since the appellant has already remained in custody for about 16 years, the conviction may be altered to under section 304 part 1, and the period be sentence be reduced um, uh, uh, accordingly. The Mr. Tripathi Lanan additional standing counsel, on the other hand, supported the impugned judgment and submitted that PW3, the widow of the deceased, has clearly stated that though he was in the house, uh, PW3 na the wife ta ki
Three. Three.
uh, but but he came out of the house on hearing altercation and saw the uh, blow given by the appellant to the deceased, and her evidence is getting corroboration from the other eyewitnesses, that is PW 6, 7, 8, and 9. The learned counsel for the state further argued that though the doctor bracket PW 16 conducted postmortem examination, has noticed one lacerated wound on the temporal region of the scalp and another lacerated wound on the left neck of the neck and one abrasion on the left knee joint, but he has stated that the cause of death was on account of cerebral hemorrhage, and the doctor has also examined the weapon of offense and gave his opinion that the injuries sustained by the deceased were possible by such weapon, and therefore the London trial court has rightly found the appellant guilty under Section 302 of the Indian Penal Code. Adverting to the contention raised by the Land Council for the respective parties, let us examine the evidence on record as to how far the prosecution has proved that the deceased met with a homicidal death. The inquest report, which has been prepared by the IO bracketary PW15, by Exhibit 5/2, indicates the nature of injury sustained by the deceased um, and the apparent cause of death. PW16 conducted postmortem examination on 16/6/2008 on police requisition, and he noticed these injuries typical, and he also noticed the following the internal injuries like this. You find that the cause of death is on account of cerebral hemorrhage. Nothing has been brought out in the cross-examination. Only a suggestion has been, of course, a suggestion has been given that he has not conducted the autopsy over the dead body of the deceased properly, and the injuries could not be possible by the weapon of offense referred to him for his examination and opinion. Therefore, we are of the view that the London trial court is quite justified in holding that the prosecution has successfully proved that the deceased met with a homicidal death. Coming to the direct evidence available in this case, prosecution has examined PW3, PW6, PW7, PW8, and PW9 as the eyewitnesses to the occurrence. PW3, the widow of the deceased, stated that the occurrence took place in the evening hours at about 7 p.m. and the appellant was her elder father-in-law. She stated that the goats of the appellant, so also their goat, was tied in a set, and on the date of occurrence, the wife of the appellant locked the set. When she requested the wife of the appellant to hand over the keys of the set, but the same was not given. And on that day, when the deceased was going to the set to tie the goats, the appellant dealt blows by means of tangia on the neck and the second blow on the head, causing severe bleeding injuries on his person. She further stated that when she reached the spot, the appellant fled away, seeing her. In the cross-examination, she has stated that she was present in her house, and there was good relationship between her family and the family of the appellant, and she was giving also proper treatment to the appellant and his family members. She specifically stated that in the cross-examination that on hearing the hulla of the deceased, She came out of the house and she heard the sound of blows given to the deceased by the appellant, for which she came out and immediately and saw the further assault to the deceased. She also stated that on hearing her cry, the neighboring people came to the spot. The contention of the London Council for the appellant that since PW3 was inside the house and came out and found the appellant fleeing away from the spot, and therefore she could not be accepted as an eyewitness to the occurrence, uh, is not acceptable in view of specific statement made in the cross examination that he was inside the house and hearing holla of her husband and the sound of blow, came outside and saw the further assault on the deceased. Since the deceased uh, had sustained two injuries, the possibility of the uh, PW3 seeing the at least the second assault cannot be ruled out. Therefore, stop. Being the widow of the deceased, she is not likely to spare the real culprit and implicate somebody falsely. She was in a close vicinity to the spot and which is in the house, and therefore her presence at the scene of the occurrence cannot be doubted at all. Her evidence is getting corroboration from the other eyewitnesses, that is PW6, 7, 8, and 9. PW6 has stated that in the evening hours on the occurrence day, while he was cleaning the rice, the deceased was going to tie his goats, and the appellant came and assaulted the deceased by means of a tangia on the head and then stop on the head. Uh, he in the cross examination he has stated that he has got good relationship with the appellant and he had no inimical relationship with him. Therefore, the witness appears to be an independent witness and having no enmity with the appellant, but all the same, he has supported the prosecution case and his evidence has not at all been shattered in the cross examination, which also corroborates the evidence of PW3. The PW7 has also stated that while he was in his courtyard in the evening hours on the date of occurrence, he found the appellant assaulting the deceased while the deceased was tying goats. And he further stated that the weapon of offense was an axe and the appellant assaulted on the head and neck of the deceased. In the cross examination, he has stated that he saw the incident from a distance of 50 cubits from his house. And further stated that there was no dispute or quarrel between the appellant and the deceased. Therefore, nothing has been brought out in the cross examination to disbelieve this witness. PW8 has stated that the occurrence took place on the last Rojo at about 6 p.m. in front of the house of the appellant, and he heard Halla and proceeded to the spot and found the appellant assaulting the deceased by means of an axe on his head and neck, and then the appellant ran away from the spot, and the deceased fell down on the ground, sustaining bleeding injury on his person. Uh, the uh, uh, Similarly is the evidence of PW 9, 9. Uh, and nothing has been elicited in the cross examination to disbelieve the evidence of these two witnesses. Therefore, the consistent evidence of the prosecution, which has been adduced to the eyewitnesses PW 3, 6, 7, 8, and 9, is that the appellant assaulted the deceased by means of tangia on the head as well as on his neck. Uh, the evidence further indicates that uh, when the appellant was taken into custody by PW 15 on 17/6/2018, he gave a statement before PW 15, uh, which was recorded under Section 27 of the Evidence Act, and led the police and gave recovery of the weapon of offense, that is tangia, in presence of the witnesses, and his statement has been proved by the IO as Exhibit 8 by 2, and MO1 is the tangia which was seized at the instance of the appellant, and the same was sent to the doctor bracket PW 16, who conducted post-mortem examination for his opinion, and PW 16 has specifically stated that he examined the axe which was produced by the Havildar and opined that the injuries on the deceased would have been possible by the weapon of offense produced before him, and the injuries were also found on the vital part of the body and could have caused the death of the deceased. The report, uh, the query report, has been marked as Exhibit 19 by 2. Therefore, the Lenin trial court has rightly held that it is on account of the assault by the appellant uh, on the head and the neck, the deceased died. Now, the question crops up for consideration as to whether, in the surrounding circumstances, uh, the ingredients of the offense under Section 302 of the IPC is made out, or the in view of the available material on record, the uh, offense is to be altered to one under Section 304 of the Indian Penal Code. It appears from the evidence on record that there was good relationship between the family of the appellant, so also the family of the deceased. And in fact, the appellant who was the elder father-in-law of the informant, bracket PW3. The evidence further indicates that both the appellant and the deceased were keeping their court in a particular state, and on the date of occurrence, the uh, wife of the appellant logged the said state, and a request was made to hand over the key, but the same was not given. The evidence further indicates that there was a quarrel between the appellant and the deceased, and during course of such quarrel, the incident in question took place, and the appellant assaulted the deceased by means of a tangia. The evidence of PW1, uh, who was posted as medical officer in Bonai Hospital, indicates that on 30 PW1, that on 13/6/2008 at about 10:30 p.m., the deceased came to the emergency OPD, and it was a referred case of Pada Hospital. The deceased was admitted, and an emergency call was given to the surgery specialist, uh, Dr. P.K. Das. However, there is no evidence on record as to that any surgery was conducted on the deceased. Rather, the evidence of PW1 indicates that uh, uh, he started IV fluid, and injection was also administered to the deceased, and uh, only a uh, mm, cardio measure treatment was provided to the deceased. And on 15th June 2008, he, on receipt of a call from the staff nurse, found the deceased in a gasping stage, and ultimately the deceased could not survive and died, and died on 15th at about 8 p.m. on that day. The um, doctor who was conducted the postmortem examination has noticed lacerated wound on the two lacerated wound, one on the right temporal region of the skull, so also on the left nape of the neck, apart from an abrasion on the left knee joint. These two lacerated wounds uh, are attributed to the against the appellant to have been caused by the tangia. Looking at the injury, it appears that sharp side of the tangia has not been used, and the blunt side has been used. And in such a scenario, it is to be judged whether the appellant intended to commit the murder of the deceased or not. Uh, in a In the case of Macha Rajam versus State of Andhra Pradesh, reported in 1995, 3 crimes 373, where an axe was used to attack the deceased and injuries were found on the back of the left ear and proved to be fatal. But since it was caused with a butt end of the axe, the it was held that the blow was dealt to the accused without the intention of causing death, but he had knowledge that his act was likely to cause such bodily injury as is likely to cause death, and therefore the conviction was altered to one under section 304 part 2 of the Indian Penal Code. In the case of Ram Asre versus State of UP, reported in 1993 supplementary 4 Supreme Court cases 218, where also the assailant used the backside of banka in assaulting the deceased. It was held that it can be reasonably inferred that such assailant had not the intention to cause the death of the victim. Otherwise, there was no reason to use the backside of the banka instead of sharp side, which in normal course could have caused the death of the victim. Uh, it was accordingly the conviction under section 302 of the IPC uh, was set aside, and instead the accused was convicted under section 304 part 1 of the Indian Penal Code. In the case of Gurdial Singh and others versus State of Punjab, reported in 2011 to Supreme Court cases 768, the uh, the blow was given by means of a gondasi, and the blunt side was used, and it was held by the honorable court that if the appellants had intended to murder Bhutta Singh, there was nothing to stop him from using the Gandasi from its true side, as that would have made it much more effective weapon. Accordingly, the uh, conviction was altered to one under section 304 part 1 of the Indian Penal Code. In the case of State of Punjab versus Constable Subhash Chandra, sorry, Harish Kumar versus State bracketed Delhi Administration, reported in 1994, supplementary 1 Supreme Court cases 462. The Honorable Court held that the looking at the nature of injuries and also the time gap between the time of infliction of the injury till the date of death, which was 2 days after the injury was inflicted, and since there was no sufficient material as to the nature of treatment given to the deceased during those 2 days, uh, the Honorable Court altered the uh, conviction from section 302 IPC to section 304 part 2 of the Indian Penal Code. In the case of Babu Singh versus State, reported in 1995 Criminal Law Journal 2439, the Division Bench of Rajasthan High Court held that there was no serious motive behind the incident, and the incident is said to be offshoot of altercation which had taken place on a very petty matter. The appellant caused the injury on the parietal region, and that too from the reverse side of the sharp cutting weapon. And it was held that it cannot be said that the appellant had intention to cause the particular injury on the head, and accordingly the conviction under section 302 of IPC was set aside, and the accused was appellant was convicted under section 304 part 2 of the Indian Penal Code. It is of course true that under the explanation 2 to section 299 of the Indian Penal Code, it is stated that where the death was caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. But in the factual scenario, when there was no previous dispute between the parties, they are related to the each other, and on a petty quarrel, uh, due to a petty quarrel between the parties, all on a sudden the appellant assaulted the deceased and has not used the sharp side of the weapon, uh, as could be inferred from the nature of injury sustained, uh, uh, mm, as per the post-mortem report findings proved by PW16. So also when there is evidence on record that there was uh, that no proper treatment could be provided to the deceased, uh, and we are of the view that uh, the conviction under section 302 of the Indian Penal Code is not sustainable in the eye of law, and the case falls under part 1 of the section 304 of the Indian Penal Code. Accordingly, the conviction is altered from section so and so to so and so. Since and we sentenced him to RI for 10 years later, RI for 10 years. Since the appellant has already undergone uh, since he has already remained in custody for the period, he shall be released forthwith if his detention is not is required in any other case. है ना? The jail criminal appeal is partly allowed. You were appointed as amicus curiae or something?
Yes, sir.
Huh?
Yes. amicus curiae.
Which date?
Last date.
Let us see that. Kebe order ହେଇଥିଲା. Is 2/7/2024. Amicus curiae for 7,500 to be paid to the London amicus curiae, and put a note of appreciation on Mr. Rajiv Lochan Patnaik, so also Mr. Tripathi. है ये पर देखिए देखिए जला पर शांत.
May I pardon?
Yeah.
Second April, item 41. That is really, Mrs. Sahu will conduct yes, from the state. And my one thing, item 45. The Arunendra Mahanti. I tried to contact him last 2 weeks, but his mobile is not in. So, my lord may engage on amicus curiae.
माने ଆସୁନାହାନ୍ତି କୋର୍ଟକୁ ନା କଣ?
Code भी देखा होने की एकदम
ଆମେ ଏନଗେଜ କରିଥିଲୁ. ଆଚ୍ଛା ଲିଗାଲ ଏଡ୍ କରିଥିଲେ.
legal aid.
ଲେଖା ହେଇଛି ଯାହା 45 ରେ.
So, Mr. Mohanty is there. Yes, ma'am.
Enrollment number.
Phone number. Enrollment.
Pardon, my lord, item 30, my lord.
We will also say that say when the matter was called, nobody was Mr. Mahanti was not present. He was appointed as so and so. Accordingly, he is disengaged, and so and so has been appointed. He is having the appointment number so on. Let a copy of the paper book be supplied to him. Taku receive kari ke nebe. Mr. So and so seeks some time to prepare the case. This matter individual commencing from 50th of So after lunch we'll take up.
Pardon, item 30, I don't have a deposition copy, my lord.
ଆପଣ ନଥିଲେ ପରା
Yes,
ସିରିଜରେ କଣ ଚାହୁଁଛନ୍ତି?
For even to direction may be given to
ଡାଇରେକ୍ସନ କଣ ଆପଣ ପେନ୍ ଡ୍ରାଇଭ ଟିକେ ଦେବେ ନେଇଯିବେ. ଆପଣ ସେଦିନଠୁ କୁହାହଉଛି ପରା ପେନ୍ ଡ୍ରାଇଭ ଟା ନେଇକି ନେଇଯାଉନାହାନ୍ତି ଏଭିଡେନ୍ସ କପି କିଏ ତ ମନା କରୁନାହାନ୍ତି. You collect the pen drive. So you can move the bail application tomorrow. Okay. Have you got the pen drive with you?
WhatsApp pen drive, I don't have pen drive.
Next week asu sir ready so ready.
अच्छा ଏଇଟା ନେକ୍ସଟ ୱିକ୍ କରିଦିଅନ୍ତୁ. ସେ ଯଦି ପେନ୍ ଡ୍ରାଇଭ ଦେବେ ଯାହା ଦେବେ ତାକୁ ପ୍ରୋଭାଇଡ କରିଦେବେ. ପେନ୍ ଡ୍ରାଇଭ ଟା ଇଜି ହୁଅନ୍ତା.
Yes, my current.
ସେ ଲେଖି ଦିଅନ୍ତୁ. ଆଇଟମ ନମ୍ବର 30 ଟା ଲେଖି ଦିଅନ୍ତୁ. ଆଇଏ ନମ୍ବର so and so Mr. Panchanan Panigrahi, Land Council 6 for an adjournment. Please this matter to be commencing from 15th July 25. Yeah. Anything, Mr. Das?
No, madam.
So we'll take up this matter.
Madam.
Which is the item?
41.
Item number 41.
And this case is based on.
Wait. Please use the mic. नहीं सीट खाओ आप हाँ एडजस्ट करिए ठीक है हाँ
May I place the FIR, madam?
yes
श्रीयुक्त पुलिस फांडी अधिकारी देवगां थाना तुसरा महाशय मु चंद्रभानु माझी पिता छाबोर माझी
चंद्रभानु माझी एग्जामिन ହେଇଛି
my lord
SPW
Procedural 4 my lord
ପଢନ୍ତୁ
ନିଜ ଗାଁ କୁଠୁଲା ଥାନା ତୁସରା ଜିଲ୍ଲା ବଲାଙ୍ଗୀର ଲିଖି ଜଣାଇବାରେ ହେଇକି ଯେ ଆମର ସାନ ଭଉଣୀ ଫାଲ ଓରଫ ବନିତାକୁ ପ୍ରାୟ 15 ବର୍ଷ ତଳେ ବଡବନ୍ଧ ଗ୍ରାମର ବ୍ୟାସ ଛୋଟାବରା ସହ
ବନିତା ହେଲା ଡିସିଜଡ ଏ କେସ ରେ ତାପରେ
ଆମର ଜ୍ୱାଇଁ ବ୍ୟାସ କିଛି କାମ ଧନ୍ଦା ନ କରି ତାଙ୍କର ସବୁ
ବ୍ୟାସ ହେଲା ଆପେଲାଣ୍ଟ
ଜମିବାଡି ଘର ଡିହ ବିକି ଦେଇ ପ୍ରାୟ ବର୍ଷେ ହେବ ଆମ ଗ୍ରାମକୁ ତାର ପରିବାର ସହ ପଳାଇ ଆସି ଆମ୍ଭେ ଭଉଣୀର ମୁହଁକୁ ଦେଖି ମୁଁ ରହୁଥିବା ଘରକୁ ମୋର ଭଉଣୀ ଓ ଜ୍ୱାଇଁକୁ ରହିବା ପାଇଁ ଛାଡ଼ିଦେଲି ସେମାନେ ସେଇ ଘରେ ରହିଲେ ବ୍ୟାସ କିଛି କାମ ଧନ୍ଦା ନ କରୁନଥିବାରୁ ମୋର ଭଉଣୀ କାମ କରିବାକୁ କହିଲେ ବ୍ୟାସ ତା ସହ ଝଗଡା କରେ ଆଜି ତା 9/9/2008 ରିଖ ରାତ୍ରି ପ୍ରାୟ 9 ଘଣ୍ଟା ସମୟରେ ମୁଁ ବନ୍ଧରୁ ଘରକୁ ଫେରିଲା ସମୟରେ ଘର ପାଖରେ ମୋ ଭଉଣୀ ବନିତା ମରିଗଲିରେ ବୁଆ ବୋଲି ପାଟି କରିବାରେ ଶୁଣିଲି ସାଙ୍ଗେ ସାଙ୍ଗେ ମୁଁ ଓ ମୋର ବଡ ଭାଇ ମୌସୁଦୀ ମାଝୀ
ଏକ୍ସାମିନ ହେଇଛି
ଆଜ୍ଞା
ଆଚ୍ଛା ହଁ
ଓ ବବାର ପୁଅ ଲାଲୁ ମାଝୀ
ଏକ୍ସାମିନ ହେଇଛି
ଲାଲୁ ମାଝୀ ହେଇନି ବୋଧେ ଲାଲୁ ମାଝୀ ଭଉଣୀ ଘରକୁ ଭଉଣୀ ଘରୁ ଦୌଡ଼ି ଗଲୁ ଘରର କବାଟ ଭିତର ପଟୁ ବନ୍ଦ ଥିଲା କବାଟ ପିଟି ଯେତେ ଡାକିଲେ ବି କବାଟ ଖୋଲିଲେ ନାହିଁ ଏଣୁ କବାଟକୁ ଶାବଳରେ ତାଡି ଦେଲୁ ଭିତରକୁ ଟର୍ଚ ଲାଇଟ ମାରି ଦେଖିଲୁ ଘର ଭିତରେ ବନିତା ଖଟ ପାଖେ ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ତଳେ ପଡିଥିଲା ଓ ବ୍ୟାସ ଟାଙ୍ଗିଆ ଗୋଟିଏ ଧରି ପାଖରେ ଠିଆ ହୋଇଥିଲା ଟାଙ୍ଗିଆରେ ରକ୍ତ ଲାଗିଥିବା ଦେଖି ଭୟରେ ଆମେ କେହି ଘର ଭିତରୁ ଗଲୁ ନାହିଁ ଆମର ପାଟି ତୁଣ୍ଡ ଶୁଣି ଗାଁ ଲୋକେ ମାନେ ଜମା ହେଲେ ବୀର ସେଠ ବହୁତ ବୁଝାଇବାରୁ ବ୍ୟାସ ଧରିଥିବା ଟାଙ୍ଗିଆକୁ ଘରେ ରଖି ବାହାରକୁ ଆସିଲା ତାକୁ କାବୁ କରି ଘର ଭିତରକୁ ପଶି ଦେଖିଲୁ ଯେ ବନିତାକୁ ବ୍ୟାସ ଟାଙ୍ଗିଆରେ ଗାଲ ବେକ ଦୁଇ ଭା ଇତ୍ୟାଦିରେ ମୁଣ୍ଡରେ ଗଭୀର ଚୋଟମାନ ମାରି ଅଛି ଭୀଷଣ ରକ୍ତସ୍ରାବ ହୋଇ ବନିତା ଅଚେତ ହୋଇ ଯାଇଥିଲା ଏହାପରେ ଗ୍ରାମର ସରପଞ୍ଚଙ୍କ ସ୍ୱାମୀଙ୍କ ଜରିଆରେ ଗୋଟିଏ ଗାଡିରେ ବନିତାକୁ ଚିକିତ୍ସା ପାଇଁ ବଲାଙ୍ଗୀର ଡାକ୍ତରଖାନାକୁ ନେଲା ବେଳେ ବାଟରେ ମରିଗଲା ବନିତାର ଲାଶ ଡାକ୍ତରଖାନାରେ ରଖି ଆମେ ଯାଇଥିବା ଗାଡିରେ ଫେରି ଏଇ ରିପୋର୍ଟ ଦେଲି ମୋର ଭଉଣୀ ବନିତାକୁ ତାର ସ୍ୱାମୀ ବ୍ୟାସ ଛତାବର ଟାଙ୍ଗିଆରେ ହାଣି ମର୍ଡର କରିଅଛି ଏଣୁ ଏହା ତଦନ୍ତ ସକାଶେ ଲେଖି ଜଣାଇଲି
ଓକେ
PW4 is the informant PW4 name may the PW4 evidence of PW4 She is the informant of the case
page
my lord running page 47 20 my lord
47 okay
47 my lord division 4 I am the informant in this case the deceased is my sister I know the accused he is my brother-in-law last year in the month of Bhadrav on a Tuesday at about 9 p.m. the occurrence took place inside the house of accused Vyasa. My sister deceased Bonita was staying with the accused Vyasa in his house at village Bodabandha. Accused Vyasa sold away all his properties and stayed in our village. Accused Vyasa was very often quarreling with my deceased sister as accused Vyasa was not doing any work. I was in my house, deceased Bonita raised Halla saying, Marigali. We three brothers went to her house. The door was closed. We pushed the door. It did not open. My nephew Artha opened the door by means of crowbar. Thereafter, Tonko lighted torch and we saw accused Vyasa who was holding a tangi stained with blood. Viraset persuaded him to keep quiet, and accused Vyasa left the tangi there and came out of the house. He controlled by the villagers. We went inside the room. We found Bonita was lying on the ground with a pool of blood. We found injuries all over her body. Then we arranged vehicle through villager Mitravanu and shifted the injured to Devga outpost. Thana. Babu, I provided a home guard and instructed us to take the injured to hospital. Then we shifted her to the hospital. The medical officer declared her to be dead. My nephew and my brother, Mausodi Machi, returned in the hospital with the dead body. Myself, Mitravanu, proceeded to the outpost. Mitravanu described the affair as per my instruction. He read over and explained the contents of the affair to me, and knowing the same to be true, I signed the affair. Then I submitted affair to Thana Babu. This is my signature in the affair, marked Exhibit 1/2. Police examined me about the occurrence. Cross-examination by the defense. Badamanda, 4 kilometers away from my house. The accused has land in our village. I cannot say the total extent of land at Badamanda. So also in our village, the sister of my father was given some land in our village which has been acquired by the accused. The accused has no land in the name of his father in our village. The accused Vyasa remained with my deceased sister for 12 to 13 years. 4 to 5 years prior to the occurrence, they were shifted to our village. I cannot say in whose favor and when the accused had sold away his properties at Badabanda. I cannot say as to whether he was selling land as he was not doing any work. It is not a fact that the accused was earning a lot, but my sister was diverting the income to her parents. It is not a fact that, as per our advice, the accused sold away his properties at Badabanda and stayed in our village. I cannot say as to whether they were living peacefully at Badabanda or not. My sister has not stated any time that the accused was torturing her during her stay at Badabanda. The accused had been to Hyderabad to work as labor for a period of 2 to 3 years. My deceased sister had also accompanied him. When my deceased sister used to visit my village, she used to speak against her husband at times. She disclosed it to her mother, and I heard it from the mother. My mother died prior to the occurrence. I had constructed the house where the accused Vyasa was staying. The land belonged to my father, which was given to the sister of my father. We obtained the consent of accused Vyasa before constructing the house. I was sleeping in my house. I, along with my wife, were sleeping in the adjacent room where Vyasa and my deceased sister were staying. The children were sleeping in another room of my house. My house and house of Vyasa situated within one compact area. It is a fact that I have stated before the police that I was returning home from village tank when the occurrence took place. Again says I have not stated before the police that I was returning from tank when the alleged occurrence took place. My wife had not accompanied me place of occurrence. On hearing holla, we all woke up and went to the spot. My house situated in front of the house where the occurrence took place. The Sankirtana was going on in the land of Dilip Das, which is just adjacent to the place of incident. About 50 to 100 villagers were present in the Sankirtan. The people attending Sankirtan reached in the spot after we reached there. By that time, we had already broken the door. No outsiders were present when the door was broken. The house was dark and not visible. After Tonka came with a torch and lighted the torch, we saw the accused Vyasa, and so also deceased. My sister was lying on the floor by the side of the cot. I cannot say the reason of conflict that took place just before the alleged occurrence. I have not had anything prior to Marigali. It is not fair that I have not stated before the police that Tonka lighted the torch and that my nephew brought the crowbar to break open the door. I cannot say as to whether Thana Babu had noted the incident in the station diary or not. It is not a fact that I had not been to the outpost before proceeding to the hospital. It is not a fact that the father of accused Vyasa had constructed the house where they were residing and that we had not obtained consent from accused Vyasa. It is not a fact that there was ill feeling between us and accused Vyasa, for which we have foisted this case against him. It is not fact that Vyasa was living peacefully with my deceased sister and that accused Vyasa has not committed the offense as alleged against him. My lord, it below 2, 4, and 5 they related to the deceased. And PW6 is the only indefinite witness of the occurrence.
What is your submission? PW2,
PW2 brother of the informant.
3 out of here.
I would 5 male. She is the nephew of the informant.
They are related to the deceased.
My lord. And PW6 is the indefinite witness. And all these my lord, evidence are consistent regarding the occurrence.
PW6 कौन कौची?
And similar manner. I'm read this PW6. Manner that is 52.
बाहर सुनी कि नासिला ना?
See, Sankirtan thela. Se shuni kiri asila.
अच्छा.
I know the accused. I know the
Oh,
deceased.
same thing.
Just
Open the door.
He brought on one iron rod and opened the door.
Acha. Deceased was lying on the floor. We saw the passer standing. Otherwise, everything is consistent.
so certain minor contradictions are there, but that's not.
So, inside a room,
My lord.
you were found. Your wife was there in an injured condition, and you were armed with a weapon. And that room was closed from inside, for which it was broke open. And the deceased was immediately shifted, and she died. And doctor must have stated that who is the doctor?
Doctor PW7.
7.
She found 21 injuries.
The doctor who conducted post-mortem examination is
PW7.
PW7.
21 injury all over the body, my lord.
Huh?
21 injury all over the body.
And the description करना. अच्छा देखिले PM report टा कितने मार्क है जी? Exhibit.
Exhibit 6, my lord.
6.
My lord.
6 टा बार करा. Exhibit करा लो.
The lower court has cited all the injuries.
Wait.
In his judgment.
तो जगह ही नहीं होता बोले क्या भाई? Inside wound, chop wound, अरे बाप रे. Scalp.
Total injuries are on the head.
Scalp, so and so. The body रो parts गुड़ाक देइछन. कोको जगह रे.
Throughout the body. Indiscriminate.
And my lord, in the accused statement, question number 1 he has accepted. He accepted question number 1. Accused statement.
Face, shoulder,
head रे कितने injury ହେଇଛି?
Head रे बेसी.
बहुत injury.
Then neck.
Accused statement रो को question पूछन?
Question number 1 he confessed that he was quarreling with his wife. Question number 1.
हाँ नहीं quarreling टा कोची अब बाकी सब मिचे बता.
हम बाकी सब मिचे मान. से गुटे केवल मान जे हम quarrel करते.
तो भाई माने कहले जे काम किछि करनथिला ये तो कहथला जे किछि काम फाम करो. सेही राग रे एई घटनाटी घटिछि. कोन आपनको सबमिशन कोन?
सबमिशन वाला लड़ा कोन तरी कि मेटेरियल्स ना डिफेंस आर्गुमेंट करे कादी.
अच्छा.
सी कहउची मु हेरा करिनी मारिनी किछि करनी. से ता क्लियर कहउची.
मिछ कथा तो कोइ छौ. आ बाकी सब तो ए जो एविडेंस गुडा को कहले 2 3 5 सब गुडा कंसिस्टेंट.
164 भी गोटे अछि.
Almost constant.
PW6 रो 164 भी अछि.
समस्त
4, 5 and 6 very clear, my lord.
2 3 5 and 6 नहीं.
2, 4, 5 and 6.
Oh, 3 नुहे
ना
No, no,
ନା
no,
କିଛି
minor.
ଜରୁରୀ
serious होता है सब।
अच्छा
Six,
2
minor.
4 5 and 6
Minor.
5 कौन करा holding a Tangia was stand with Brown on the request answered by sir then he told him based on short of it. Look on JCRL numbers 27 of 2010. The appellant Basso Chattabara faced trial in the court of and an additional session is Balangir in sessions case number 19/14 of 2009 for offense punishable under section 302 of the Indian Penal Code for committing murder of his wife Vanita Chattabara hereafter the deceased. The London Trial Court by impugned judgment and order dated 31/5/2010 found the appellant guilty of the offense charge and sentenced him to undergo imprisonment for life and to pay fine of rupees 25,000 in default to undergo RI for a period further period of 2 years. As per the first information report lost by PW4 Chandrahanu Maji, the prosecution case, in short, is that the younger sister of the informant, namely Banita, married to the appellant 15 years prior to the occurrence. The appellant was not doing anything and he was unemployed and sold the landed properties and since 1 year prior to the occurrence he came to the village of the informant and stayed in the family of the deceased. Parental house, into the parental house and stayed there. Even after staying in the house of the deceased, the appellant was not interested to do any job in spite of the persuasion of the deceased. And over this issue, there used to be quarrel. The appellant was quarreling with the deceased. It is the further prosecution case that on 9/9/2008 at about 9 p.m. when PW4 returned home from the embankment, he heard shriek of the deceased, and he, along with his elder brother, Mousudi Maji, bracketed PW2 and Lalu Maji rushed to the room where the deceased was staying with the appellant and found that the uh, door of the room was locked from inside. Uh, even though they knocked the door, but nobody opened the same, for which the door was broke open by using a crowbar, and using a torchlight, it was found that the deceased was lying, bleeding injuries on the ground, and the appellant was present uh, in the room and standing with holding a tangia, and there was also blood in the tangia. Um, seeing the ghastly uh, crime, the informant and others shouted, for which the villagers congregated there, and after much persuasion, the appellant came out of the room with the tangia, and thereafter the villagers captured him, and after entering into the room, it was found that the appellant assaulted the deceased on his face, neck, arms, and other parts of the body, and the deceased was lying in a senseless condition with profuse bleeding. It is further stated that with the help of the sarpanch of the village, the deceased was taken for treatment to Balangir hospital in a vehicle, but on the way she expired. And thereafter, the first information report was lodged by PW4 before the Deoga outpost, and after receipt of the report, K.C. Tripathi, Kanu Charana Tripathi, bracketed PW9, found it to be a cognizable case and accordingly entered the same in the outpost station diary entry, and then treated the same as FIR, took up the investigation and sent the report to officer in charge of Tusra police station for registration. PW11 Subhash Chandra Bisoi, the officer in charge of Tusra police station, after receipt of the report, registered Tusra PS case number 163 dated 10/9/2008 under section 302 of the Indian Penal Code against the appellant. PW 11 took up investigation of the case, and during course of investigation, he proceeded to village Kathuria.
10 and 11 is IO, my lord.
Huh?
10 and 11, both is IO.
No,
Both
no,
are IO.
10 is
10 is initial.
T is
Which one is?
No, initial 11, 10 is the
Ah,
main IO.
that is right.
He proceeded to village Kathuria, and on the way, he visited Deoga outpost and issued command certificate in favor of the constables to proceed to DHS Balangi to guard the dead body. Then he visited the dwelling house of the appellant and guarded the spot and examined the witnesses, recorded their statements, and returned back to the police station with the appellant. He sent the message to SP Balangir for deputation of scientific team to the spot for collection of physical proof. And then he came to DHS Balangir, held inquest over the dead body of the deceased in presence of the witnesses, and prepared the inquest report exhibit 2. Thereafter also he examined some witnesses, recorded their statements and the dead body for post-mortem examination and handed over the charge of investigation to Sesadev Bariha, PW10, as per the direction of the Superintendent of Police Balangir. PW10, after taking over the charge of investigation, also visited the spot and prepared the spot map, seized one Jangia from the spot under seizure list exhibit 3, and he also seized sample earth, Boston earth, broken bangles, caught hair in presence of the witnesses as per seizure list exhibit 2. Then he also seized an electric valve from the sport house as per seizure list exhibit 10, and also seized one iron crowbar on production of Martotrana Maji as per seizure list exhibit 11. The appellant was sent by him to the government hospital Thusura for collection of nail clippings, and he also seized some packets containing the nail of the appellant and blood, etc., as per seizure list exhibit 9. On 11/9/2008, he seized the lungi of the appellant in presence of the witnesses as per seizure list exhibit 12, and the appellant was again sent to DHS Balangir for collection of blood sample and blood grouping. And then he was forwarded to court. The wearing apparels of the deceased were seized on the production of the constable who escorted the dead body as per seizure list exhibit 14. After receipt of the postmortem report on 15/9/2008, he made a prayer for recording the statements of some witnesses. He made a prayer before the SDGM Balangir, London SDGM Balangir, for recording the statements of some witnesses under section 164 CRPC. He also sent the Tangia with a query regarding possibility of the injury sustained by the deceased with such weapon, and the received the query report and sent requisition to RI Udasingha to ascertain the owner of the house where the occurrence took place, and accordingly the report was received with a sketch map. The sample blood of the appellate from through the jail doctor was collected by the IO after making a prayer to the learned SDGM Balangir, and further prayer was made before the learned SDGM to send the exhibits to the Deputy Director RFSL Sambalpur for chemical examination. And the afterwards also he received the C report marked as Exhibit 21. On completion of investigation on 6/1/2009, PW10 submitted charge sheet against the appellant under Section 30 of the Indian Penal Code. After the case was committed to the Court of Session, the London Trial Court framed the charge against the appellant as aforesaid, but the appellant pleaded not guilty and claimed to be tried. In order to prove its case, the prosecution examined 11 witnesses for a detailed curriculum, and prosecution also exhibited 22 documents, also two material objects. The defense plea of the appellant is one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the postmortem report indicates that the deceased has sustained as many as 21 external wounds, and the doctor has also opined the cause of death of the deceased due to injury to the vital organ like brain and spinal cord. The query report submitted by the doctor regarding possibility of injury on the deceased by MO1 was also taken into account by the London Trial Court, and it was held that the prosecution has successfully proved that the deceased met with a homicidal death. The London Trial Court observed that there is no direct evidence in the case. However, the case rests on the circumstantial evidence. 4 circumstances were jotted down by the London Trial Court in paragraph 7 of the impugned judgment, which are as follows. The London Trial Court considered each of the circumstances after assessing the evidence in that respect, and came to hold that the prosecution is successful in proving each of the circumstances. The London Trial Court rejected the contention raised by the London Defense Counsel that the witnesses are interested and therefore their evidence is to be disbelieved. The After analyzing the evidence of PW2, 4, and 6, it was held that their evidence is truthful, and since the occurrence has taken place inside the bedroom where the deceased and the appellant were only there, and there was no other person, and the cause of death of the deceased was due to injury to the vital part, and there, therefore there was remote possibility of causing such type of injuries by any other person who was not in the room. Since the room was in the exclusive occupation of the couple, the London trial court further held that the burden of proof uh, was upon the appellant to show under what circumstances death was caused the disease. However, the appellant has failed to discharge the burden, and uh, the circumstances which are appearing against the appellant form a complete chain of evidence not to leave any reasonable ground for the conclusion consistent with the innocence of the appellant, and so that in all human probability the act must have been done by the appellant. Accordingly, the appellant was found guilty under section 302 of the Indian Penal Code. Mr. Ravindranath Nayak, learned counsel appearing for the appellant, submitted that the witnesses are related, PW2, 4, and 5 are related to the deceased, and therefore there is likelihood of false implication of the appellant, and the since the case is based on circumstantial evidence and the circumstances are not clinching, therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mrs. Sahoo, London counsel appearing for the state, on the other hand, supported the impugned judgment, and submitted that not only the prosecution has established the motive behind the commission of crime on the part of the appellant, but also in view of the circumstantial evidence which is appearing on record in this case and deposed to by PWs 2, 4, 5, and 6, and the manner in which the deceased and the appellant were found in the inside their bedroom, and the appellant was holding the uh, bloodstained tangia, and the deceased was lying with profuse bleeding injuries, and no explanation has been offered by the appellant as to how the deceased sustained such injuries. And since it's a case of homicidal death, and the manner in which the appellant brutally assaulted the deceased, mainly on the vital parts of the body, the London trial court has rightly found the appellant guilty under section 302 of the Indian Penal Code. Therefore, this JCRLA should be dismissed. Adverting to the contention raised by the land counsel for the respective parties, and we think it proper to first deal with the evidence on record as to how far the prosecution has successfully established that the deceased met with a homicidal death. The inquest report prepared by the PW11, which has been marked as Exhibit 2, reveals the nature of the injuries on different parts of the body, and the doctor bracket PW Doctor PW
W7.
PW7 who conducted post-mortem examination over the dead body of the deceased at DHS Balangir noticed this following 21 injuries. এটা সেই judgment রাশি quote করে দেবে paragraph page number internal page হচ্ছে 5 না judgment external page the on dissection he also found this following যেটা লিখে দেবে না যা আছে ওরা সব লিখতে দেবে query গুলির মধ্যে লিখতে দেবে after going through the inquest report, so also the post-mortem report finding and the evidence of the doctor, we are of the bracketed PW7, we are of the view that the finding of the London trial court that the prosecution has successfully proved the that the deceased met with a homicidal death is perfectly justified. Coming to the evidence on record, rightly the London trial court has held that there is no direct evidence in the case, and the case is based on circumstantial evidence. The witnesses like PW2, 4, and 5 who are related to the deceased have stated the motive stated about the frequent quarrel between the deceased and the appellant, as he was a jobless person and he was doing nothing in spite of repeated persuasion of the deceased. PW2 has stated that the appellant sold away the immovable properties and was settled in their village, and he was not working regularly, for which the deceased was quarreling with him, and the appellant used to assault the deceased whenever she was asking the appellant to work. Similarly, PW4 with the informant in the case has also stated about the appellant selling away all his properties and very often quarreling with the deceased as he was not doing any work. PW5 as no, PW5 is not related, so only two are related.
PW6 is not.
PW5 is also not related. As a PW5 2 and 4. Therefore, the circumstance which has been jotted down by the London trial court that there used to be frequent quarrel between the deceased and the appellant, as the appellant was not doing any work regularly, has been established through the evidence of PWs 2 and 4. The next circumstance appears is that at the time of occurrence, only the appellant and the deceased were present inside the bedroom of inside their bedroom, and the witnesses heard uh, the shout of the deceased Morigali Morigali, for which they rushed to the room but found the room was locked from inside, and uh, then the room was broke open, and it was found that the appellant was standing holding a tangia stained with blood in the hand, and the deceased was lying in the room having hot injuries. PW2 has stated that when he heard uh, Ullah uh, raised by the deceased from inside her room, went along with others and knocked the door, but nobody opened the door. And he further stated that one Artotrano opened the door by using a crowbar, and then they entered inside the room, and the room was dark, and uh, it was as a PW6 lighted a torch, and then they saw the appellant was raising an axe clotted with blood, and the deceased was lying inside the house in a pool of blood, and she was struggling when they saw her. He has further stated that um, the deceased was persuaded, sorry, the appellant was persuaded uh, to come down, and then he threw away the axe and came out of the house, and the outsiders were present there. They caught hold of the appellant, and then they saw the deceased was lying with bleeding injuries all over her body and mostly on the head. And then they arranged a vehicle and shifted to Deoga outpost, where the doctor declared him dead. In the cross examination, PW2 has stated that he reached the doorstep of the appellant fast, and then the others reached there soon after, and he dealt kicks and fists to the door, but it did not open. The uh, uh, villagers, no, immediately after entering into the room, the uh, uh, PW6 lighted the torch. Nothing further has been brought out in the cross examination to disbelieve the evidence of PW2. Similarly, the London Council's contention, PW4 PW4 is also uh, uh, the the brother of the deceased, and he has also stated that hearing the shout of the deceased, uh, they uh, came to the uh, house of the deceased and found the door was closed. Then the door was, but it couldn't. It didn't. And then by using crowbar, one Arthur opened the door, and then PW6 lighted the torch, and the appellant was found holding a tangia stained with blood, and the appellant was persuaded to keep quiet, and for which he left the tangia there and came out of the house, and he was caught hold of by the villagers, and they found the deceased was lying on the ground full of blood with injuries all over the body. Therefore, Acha, in the cross examination, he has stated that he was sleeping in the house, and he, along with his wife, were sleeping in the adjacent room where the uh, appellant and the deceased were staying. He further stated that his house, so also the house of the appellant, situated within one compact area. The uh, learned counsel for the uh, appellant submitted that the PW2 as well as PW4 are closely related to the deceased, and therefore every chance of false implication is there. We are not inclined to accept such a submission. Close relatives or related witnesses are not necessarily false witnesses, and their presence at the scene of occurrence cannot be doubted at all because it is their own house. And hearing this out, they came to the spot room and deposed what they saw, and nothing has been brought out in the cross examination to disbelieve the evidence of these two vital witnesses. Their evidence is also getting corroboration from PW5, who has stated that hearing the cry, uh, he came out of the house and saw that the appellant was holding a tangia on the doorstep of his house, which was stained with blood. And then, uh, on the request of Bir Set, the appellant put down the tangia on the floor, and then he was caught hold of by the villagers. And he further stated to have noticed bleeding injuries all over the body of the deceased, uh, and further stated about the shifting of the deceased to the hospital. PW6 uh, has also stated in the like manner, uh, and stated that when the door was not opened, he brought one iron rod and opened the door, and then lighted the torch and saw the deceased was lying on the floor with bleeding injuries. Uh, and the appellant was standing near the deceased, holding one tangia stained with blood. And seeing the light, the appellant uh, chased us, chased them. PW5 and PW6 are independent witnesses, and their evidence corroborate the uh, evidence of PWs 2 and 4. Nothing has been brought out in the cross examination of these two witnesses to disbelieve their testimonies. Therefore, the circumstance which has been jotted down by the London Trial Court as circumstance number 3 has been established by the prosecution. The 3 and 4 कर दो, है ना? The PW5 को जो लिखी ना, अच्छा সেটা কাটি দিন তাহলে PW5 লিখে দিন যেটা খালি PW6 টা ইন্ডিপেন্ডেন্ট আছে PW5 stated is the nephew of the deceased and he has stated like this then the all the circumstances which has been adduced by the by the prosecution has been put to the accused in the accused statement, but the accused has stated, except stating that it is all false, uh, he has not come with any explanation at all. When the accused was found inside the bedroom, inside his bedroom, where he along with the deceased were only remaining, were staying, and the deceased was found with bleeding injuries lying on the bed, and the appellant was holding an axe, and the room was closed from inside, which was broke open. It was uh, the burden shifts to the accused as to how the deceased died and who is responsible for the same. The appellant has not offered any explanation at all. Sit down. Section 106 of the Evidence Act which deals with burden of proving fact, especially within the knowledge does not relieve the prosecution of its burden to prove the guilt of the accused beyond a reasonable doubt. This section applies to the cases where the prosecution has succeeded in proving the facts from which a reasonable infer other facts, unless the accused, by virtue of his special knowledge regarding such fact, failed to offer any explanation which might drive the court to draw a different inference. Section 106, the provision under Section 106 is unambiguous and categoric in laying down that when any fact is especially within the knowledge of a person, comma, the burden of proving that fact is upon him. If any explanation that the accused chooses to give is not proved beyond doubt, he cannot claim to be innocent. But even so, if his explanation shows any reasonable doubt on the prosecution story, he would be entitled to an acquittal, not because he proves the facts and circumstances referred to, but because the prosecution has failed to establish his guilt beyond reasonable doubt. In other words, if the court thinks that the explanation given may reasonably be true, although the court is not convinced that it is true, the accused is entitled to be acquitted. The onus of proof is not changed in such type of cases. It always remains on the prosecution. Prosecution has to lead evidence to substantiate its accusation. If facts within the spatial knowledge of the accused are not satisfactorily explained, it is a factor against the accused. When an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature and amount of evidence to be laid by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. The burden would be comparatively lighter character. In view of Section 106 of the Evidence Act, there will be a corresponding burden on the accused to give cogent explanation as to how the crime was committed. The accused cannot get away by simply keeping quiet and offering no explanation. On the supposed premise that burden to establish the case lies entirely upon the prosecution and there is no duty at all on him to offer any explanation. In the case in hand, the circumstances which has been established by the prosecution are clear and the circumstances clear and conclusive in nature. And in our humble view, the circumstances make out a complete chain of evidence. And it doesn't leave any reasonable ground for the conclusion consistent with the innocence of the appellant. When the appellant has not offered any explanation at all, and simply stated that the witnesses are telling falsehood. Therefore, it can be held that he has failed to discharge his burden under Section 106 of the Evidence Act. In our humble view, the London Trial Court has rightly found the appellant to be the author of the crime. The manner in which the crime has been committed, the number of blows the appellant has caused to the deceased on different parts of the body, including on the vital part like head and face, shows that his intention was nothing but to commit the murder of the deceased. The सेठ जो ये लिख दो the weapon of offense এটা ওটা add कर दो. The weapon of offense was seized from the spot and it was sent to the doctor, and the doctor also, on examining the same, opined that the injuries caused to the deceased are possible by such weapon. तापर लिखिए जो complete chain में, no? The appellant was found in the spot. Therefore, we are of the view that there is no illegality or infirmity in the impugned judgment. According to the jail criminal appeal being devoid of merit, stands dismissed. You have been engaged by the legal aid or amicus curiae?
না আমি গস করি না
Legal aid. দেখি তো চিঠি ଗୋଟେ ଦେଇଥିବେ କାହାକୁ ଗୋଟେ ଚିଠିଟା ଦେଇଥିବେ ଏ ଫାଇଲଟା ଦେଲ ଟିକେ ହଁ ନାଇଁ ନହେଲେ ଡକୁମେଣ୍ଟ ଅଛି କି
engagement ଅଛି
ଦେଖୁନାହାନ୍ତି ଆଉ ସେଇଆ ତ ଆମେ ଖୋଜୁଛୁ ଆଉ ସେଇ ହଁ it should do like so and so who has been engaged by the Orissa High Court High Court Legal Services Committee Orissa Cuttack as the counsel for the appellant argued that say ଯୋଉଟା ଲେଖିବେ ନା ନାଁ ଲେଖିବେନି ସେଇଠି ଲେଖିଦେବେ ସେଟା ହେଲା. So Mrs. Sahu,
Ma'am.
that's all for today. Mrs. Sahu for now.